Modern international human rights law and global activist movements emerged in the decades following the end of the Second World War. During this period, the legal framework and institutions that comprise the international human rights system were established under the auspices of the United Nations and regional organizations such as the European Union and the Organization of American States. International human rights are founded on a network of international, regional, and national laws and institutions that outline entitlements and enforce these rights. Since the adoption of the Universal Declaration of Human Rights by the United Nations General Assembly in 1948, a network of human rights laws have developed to protect an ever-growing list of individual and collective rights that governments and the international community are obligated to protect. In this class, we'll be examining the laws, the policies, and institutions that make up the international human rights system. A key document that frames the international human rights system is the United Nations Charter, which provides the United Nations with the authority to make human rights laws. Article 13 of the UN Charter mandates the United Nations to initiate studies and make recommendations for the purpose of assisting in the realization of human rights and fundamental freedoms for all. The United Nations human rights system is founded on three key documents. These are the Universal Declaration of Human Rights of 1948, the International Covenant on Civil and Political Rights of 1966, and the International Covenant on Economic, Social, and Cultural Rights of 1966. Together, these three instruments constitute the International Bill of Rights. They outline a wide range of individual and collective rights that countries are expected to uphold. While some of these United Nations human rights instruments are declarations which are not legally binding on member countries, the covenants are considered legally binding on countries that have signed up to them. The first article of the Universal Declaration of Human Rights affirms individual rights and liberties. It states, "All human beings are born free and equal in dignity and rights. They are endowed with reason and conscience and should act towards one another in a spirit of brotherhood." The adoption of the Universal Declaration of Human Rights following the Second World War marked the international recognition of certain fundamental human rights and freedoms as inalienable universal values, to which all individuals are entitled simply by virtue of their humanity. The United Nations Covenant on Civil and Political Rights and the Covenant on Economic and Social Rights both assert individual liberties and the collective rights of peoples. The first article of the Covenant on Civil and Political Rights states, "All people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development." The inclusion of self-determination within the United Nations system set the tone for the progressive expansion of the boundaries of international human rights law. A key aspect of the progressive realization of an all-inclusive international human rights system has been the emergence of specialized conventions on the human rights of categories of people such as refugees and migrants, women, children, people with disability, and lately sexual minorities. These specialized international human rights conventions include the International Convention on the Elimination of All Forms of Racial Discrimination, the Convention on the Elimination of All Forms of Discrimination against Women, the Convention Against Torture, the Convention on the Rights of the Child, the Convention on the Rights of Persons with Disabilities, and the United Nations Declaration on the Rights of Indigenous Peoples. Despite these international human rights laws, in many countries around the world, certain groups continue to be systematically disadvantaged because they are discriminated against. Such groups are often differentiated by race, ethnicity, age, sexual orientation, religion, caste, or gender. Sometimes such human rights violations occur because countries lack the resources or institutional capacity to protect the rights of politically and socially marginalized groups. The police system and the judiciary may not have the capacity to enforce these rights. At other times, however, human rights violations are due to the absence of political will by governments to challenge entrenched prejudices and to fully extend human rights protection to marginalized groups. Apart from legal instruments, the United Nations has developed a network of human rights enforcement institutions and mechanisms. Human rights declarations and conventions may be a useful first step in protecting rights, but these laws and declarations are useless if they cannot be enforced. The primary responsibility for enforcing international human rights guarantees rests with sovereign states. United Nations institutions charged with monitoring and enforcing human rights include the United Nations Human Rights Council, based in Geneva, Switzerland. This is the United Nations principal mechanism and enforcement forum for the promotion and protection of human rights. The work of the Human Rights Council is supported by the Office of the United Nations High Commissioner for Human Rights. United Nations human rights monitoring and enforcement organs also include several human rights committees and treaty bodies. These are independent bodies of experts appointed to monitor and report on how well countries that have signed up to UN treaties are enforcing them. The United Nations Human Rights Enforcement Mandate is also supported by the judicial bodies such as the International Court of Justice and the International Criminal Court, both of which are based in The Hague in the Netherlands. The International Court of Justice is the main judicial organ of the United Nations. Established in 1945 by the UN Charter, its main functions are to settle legal disputes submitted to it by member states and to give advisory opinion on legal questions of international concern. The International Criminal Court was established in 2002 to prosecute individuals for international crimes of genocide, crimes against humanity, war crimes, and crimes of aggression. An important part of the international human rights system are regional instruments and enforcement mechanisms, such as the European Convention for the Protection of Human Rights, the American Convention on Human Rights, and the African Charter for Human and People's Rights. The question that often arises is this: why are regional or even national human rights laws necessary? If human rights are indeed universal, shouldn't there be a single universal standard and human rights regime for everyone? The simple answer is that regional and national human rights regimes are seen as complementing rather than duplicating or contradicting United Nations universal human rights regimes. For example, the European Convention for the Protection of Human Rights of 1950 affirms universal human rights, and the European Court of Human Rights in Strasbourg, France, applies both international and regional human rights standards. Similarly, the American Convention on Human Rights, adopted in San Jose, Costa Rica in 1969, reiterates the civil and political rights provisions of the Universal Declaration of Human Rights. It affirms the right to life, freedom of expression, the right to participate in government, among other fundamental human rights. The Inter-American Court, created in 1978, applies and interprets the American Convention on Human Rights. The African Charter of Human and People's Rights upholds individual liberties, but also emphasizes the collective rights of peoples. It includes some unique human rights provisions that reflects the colonial history of the continent, such as the rights of colonized people to be free and the rights of people to freely dispose of their natural resources and wealth. The African Charter also emphasizes the correlative relationship between human rights and human duties. It includes provisions such as the duty of citizens to the state and the duty of children to respect their parents and take care of them at old age. Similarly, the Arab Charter on Human Rights, adopted by the League of Arab States in 1997, emphasizes the right of Arab nations to self-determination and to safeguard their resources. While international and regional human rights instruments provide for the broad protection of universal human rights, the most direct protections of citizens' rights can be found in national human rights systems. Most countries of the world have a Bill of Rights included in their national constitutions or other national legislation. The United States Constitution, for example, includes a Bill of Rights, which are the first 10 amendments of the Constitution. The Canadian Human Rights Act was passed in 1977 to ensure equal opportunity to individuals who may be victims of discriminatory practices based on a set of prohibited grounds such as race, ethnicity, gender, disability, or religion. Finally, human rights non-governmental organizations, or NGOs, play a key role in the international human rights system. Through litigation, advocacy, human rights education, and public awareness campaigns, these human rights organizations pressure governments and international agencies to protect fundamental human rights. Two of the world's most important human rights NGOs are Amnesty International and Human Rights Watch. Both organizations campaign internationally against human rights abuses and monitor human rights violations around the world. We can identify 4 levels of human rights protection. First are the United Nations Declaration, Covenants, and enforcement mechanisms. Second are the regional mechanisms for human rights protection, such as the European Court of Human Rights. Third are the national and provincial institutions to protect citizens and their rights, such as the Canadian Human Rights Commission. And finally, we have the important roles of human rights non-governmental organizations, or NGOs. Together, these institutions constitute the framework of modern international human rights system. It is true that the enactment of human rights laws and the establishment of human rights courts do not in themselves translate into improved human rights conditions for citizens in practice. This is particularly true in countries with repressive or authoritarian governments. However, these laws and institutions are important because they provide the legal and moral justifications for people to assert their human rights.